they're not going to group under Rule D. They're excluded from grouping under Rule D. You can't just add up the dollars taken in robberies and have one composite harm. The guidelines don't allow you to approach it in that fashion. If you grouped under Rule D, good, you're probably through. If not, you got to look at the rules A, B, and C and see if the counts will group there. If counts group under rules A, B, or C, you apply the guidelines separately to get an offense level for each count. And then you use the highest offense level. Now let me give you some examples and that'll explain what this slide is saying to you. I have 2 counts of conviction. And I've looked these counts up in my statutory index, and I see the guideline that's used for each of those, and it turns out that I didn't group them under Rule D. So I know I didn't treat them as a composite harm by applying the guidelines one time for both of those counts. But maybe they're going to group under Rules A, B, or C. Now for count 1, I looked in the statutory index, I know which guideline I'm using. I apply the Chapter 2 guideline. I apply the Chapter 3 adjustments, all the way down to obstruction. Now, what that means, and you've looked at the worksheet, obstruction is at the bottom of the worksheet A. In other words, I've applied the worksheet A for count 1. Now, for count 2, I've done the same thing. I've looked in the statutory index and gone back to the Chapter 2 guideline and applied Chapter 2 and Chapter 3. And at the bottom of that worksheet A, I've got a number for that count as well. That number is called the adjusted offense level. So I have an adjusted offense level for each of those counts. What I'm going to do now is I've come up with that number, and now I'm going to go through this process to decide how am I going to group these counts. Do they group under Rules A, B, or C? Rule A says you're going to group counts together if they have the same victim and they're the same act. My set of facts are this. I got 2 counts of conviction. One count is for bid rigging. The other count is for mail fraud. The bid rigging count involves the guy, rigging a bid. The mail fraud count is the mailing in of this bid that was the bid rigging. 2 counts of conviction, 2 violations of law. But the question is, do we treat it as 2 separate harms, or do the guidelines treat it as one composite harm? And the commission says, who's most victimized by the bid rigging? Well, it's going to be this agency or whatever that was the object of this bid rigging. Who was most victimized by the mail fraud? Well, it's whoever you mail this bid to. So you have the same victim. It's the same act. Mailing in that bid was one act, and that created the bid rigging. So since it's the same victim, the same act, the commission says this is best treated as one composite harm. Now we took out a worksheet A for each of these counts of conviction to apply the guidelines. For the bid rigging, we applied worksheet A. It was an 11. For the mail fraud, we applied a worksheet A. It was an 8. But when you group, you take the highest offense level, in this case 2 higher offense level, of those that go into the group. This is one composite harm. And the composite harm gives us an offense level of 11 for this group. Grouping under Rule B, a similar type of grouping because you have to have the same victim, 2 or more acts part of the same scheme. You had someone who made a false statement. And they made a false statement so as to be able to register to vote, and then they went in and voted in that election and therefore obstructed an election. 2 counts of conviction, 1 for having made the false statement, the second for having obstructed the election. You say, who was most victimized in making the false statement? This election that was at hand. Who was most victimized when you went in and obstructed this election? This election at hand. Same societal interest, same victim there. With the same victim, it wasn't the same act, but there were 2 or more acts part of the same scheme. We say, treat this as one composite harm. You apply the worksheet A for this count of conviction for obstruction. You apply the worksheet A for the count of conviction for the false statement. Having decided to group those together under Rule B, then it's the offense level, which is the higher of the 2. Rule C, you have robbery of a bank and assault of a teller. The bank robbery guideline, as you apply the bank robbery guideline, as we looked at earlier today, it says, did you have injury, bodily injury, serious, permanent, add 2, add 4, add 6. This assault offense, this count of conviction, assume this happened on federal property where there was some jurisdiction they could have even charged the assault on the teller. You say, well, our robbery guideline, it would have been a 22, but we added 2 more levels to take into consideration that injury to this victim. Well, that injury to the victim that we've taken into consideration here really is the essence of this assault count. So we really have one composite harm, so let's treat those as one composite harm, group them together under Rule C. So we have a 24 and a 17. Grouped together, it's an offense level of 24 for the group. If you commit 4 robberies, you've got 4 harms. You commit 4 rapes, you have 4 harms. The commission has not treated those as a composite harm. But now what do we do if we have more than 1 harm? How do we approach that? Well, the incremental increases. Assignment of units and additional offense levels. Incremental increases. If there's more than 1 group, here's the process. You compare the offense level of the highest group to the offense levels of the other groups. You compare each of my harms. What's my offense level for each of my harms? I increase the offense level of the highest group, the highest harm, according to a table. Now, this is all just purely almost mathematical at this point. I've got the 5 counts of fraud that I've grouped together because they all grouped under Rule D, and the offense level for those was a 23. I had a robbery and assault of the same victim, and I grouped those 2 counts together, and they got a 24. I had a separate robbery that was a 28. Out of, 5, 6, 7, 8, out of 8 counts of conviction, going through my grouping rules, I decided, well, 8 counts of conviction, but just really 3 harms. And here's the offense levels for the harms. Now, I want to give some increase in punishment because there's not just 1 harm here, there are 3 harms. We want to give some more punishment for 3 harms. At 3D 1.4, you look at the offense levels and you add units based on those. The highest offense level, whatever that number is going to get a unit. Unit doesn't mean anything, it just translates into something. 1 to 4 levels less serious picks up a unit, 5 to 8 levels less serious, half a unit, 9 or more levels less serious, no units. So let's assign units here. We have a 23, a 24, a 28. Well, the highest of those is the 28. It picks up a unit. The 24, in comparison to the 28, that is close enough in harm that it picks up a unit. The 23 and to the 28, that's 5 offense levels difference. It's remote enough that it picks up a half a unit. Again, looking at the guidelines table, it's just a table in the book. 3D 1.4, you total the units, 2.5. And at 3D 1.4, it says if you have 2.5 units, that's going to translate into 3 additional offense levels. 3 additional offense levels are going to be added to what? Well, our highest group that we were using as our most serious harm was a 28. We've added the 3 additional offense levels, and we have an offense level of 31, which is our offense level for these multiple counts of conviction. I got 8 counts of conviction, but my offense level of 31 tells me how far down on this table I go, and that 31 is for these multiple counts of conviction. And my criminal history category used with that gives me a range. Now, this range says give this guy 12 to 14 years. Then you go back with your multiple counts of conviction and say, okay, the guidelines call for 12 to 14. The judge says, well, I think 12 years is the right sentence. And how did I get to 12 years? Well, you say, well, count 1 carries a statutory penalty of 20 years. Well, I'm going to give you 12 years on that count. And all the rest of the counts, I'm giving you 12 years to run concurrently. Now, if I can't give 12 years because some count just has a maximum penalty of 5 years, then I can just give you 5 years on that count. But it all runs concurrently because what I know is the correct sentence is 12 to 14. I'm just using the multiple counts at this point to build up to give that 12-year sentence. You're not going to say, well, I'm going to run them all consecutively, 12 and 12 and 12 and 12, because, hey, wait, then you're giving this guy like a 60-year sentence, a 60-month sentence, and you were just going to give, say, 12 months. And the final thing I want to make a point is that acceptance of responsibility is done after you come up with this number. So on that set of facts, we just came up with that 1 offense level for all those multiple counts. You then, from that point, say, is this guy going to get 2 or perhaps 3 levels off for acceptance of responsibility?
The district courts should be very hesitant to decide that a factor can never be a ground for departure. That the district courts are supposed to use their unique perspective and their ability to really understand and compare cases to determine whether the circumstances of that particular case warrant a departure, rather than deciding whether a factor per se is excluded from departure. It's clear from other circuits outside the Ninth that circuits can say that certain factors can never be a ground for departure. But a circuit like the Ninth is basically, in effect, throwing things open to the district court and saying, look, if it's not prohibited, if you want to depart, you can go ahead and depart. I strongly encourage probation officers to recommend the departures they think are appropriate and recommend to the judges of how consistent with Kuhn and the circuit law they can lay out and argue for a departure. In other words, what kind of findings should the district court make to support the departure that he or she wants to make? Probation officers can serve your judges well by identifying a number of what the factors are and even how the judge could formulate the findings. Similarly, defense attorneys and prosecutors need to give proposed findings of fact and conclusions of law to the judge, particularly in the area of departures. So you can argue not only that you want a departure in a certain direction, that you want it for a particular factor, but how the judge can lay it out in a way that he or she has a reasonable chance of being affirmed on appeal.
Welcome back yet again. thanks for hanging in there with us, particularly after that units discussion. In any event, on the video that we just saw at the end, it was the shortest of presentations on departures. Obviously, you're going to need some more knowledge of departures in order to be an effective advocate or to correctly apply the guidelines and give the court good guidance about departure factors. We have a couple of very good resources for you regarding departures. One of them is the Sentencing Commission's departure document, and that's a document that's available from our website. That document looks at all the case law that is developed in certain areas of departures. And I think the best thing about that document is the way that it's laid out. It's not only useful, but it's very usable. So I certainly recommend that to you. And it's updated quarterly, so that document is ever evolving. Also, another thing that you will find quite helpful by way of a resource regarding departures is a departure video presentation that occurred last year on the FJTN network. And it was done by staff members at the Sentencing Commission. Now, I'm not sure when that will be rebroadcast again. I don't think it's part of the Valentine's Day special. But nonetheless, we do know that you can get access to that by coming again to our website. And there you can contact us, and we will send copies of that to you. And as I recall, I think that we are probably more economical than Blockbuster, and we don't really care, how long they keep it as much as Blockbuster does.
That's right.
In fact, I don't even think you have to rewind. We're just glad to know that you've looked at the thing. So that's pretty much the situation there. Now, are we ready to answer some more questions?
I'm ready, Rusty. Are you?
Okay, I think I am, assuming we have some. Nancy, do we have some?
Absolutely, Rusty. We have some really excellent questions.
Oh, good.
But I think I'll direct this to Rachel this time.
So you want an excellent answer as well, I see.
That's
Okay.
the,
Thank you,
yes,
Rusty.
yes, absolutely. If a defendant is convicted of only one count of bank robbery, will relevant conduct allow consideration for other robberies that the defendant may have committed?
That is an excellent question, Nancy. As you had seen from our videotape, Rusty did talk about this notion of expanded relevant conduct. The relevant conduct guideline at 1B 1.3 provides in subsection A2, when you're applying relevant conduct, to include acts of the defendant that were part of the same course of conduct or common scheme or plan as the offense of conviction. This notion of expanded relevant conduct that we've talked about. The nice thing about this expanded relevant conduct application is that the guidelines also tell you for what offenses it applies. In other words, that 3D 1.2D, we give you a listing of offenses that expanded relevant conduct applies to. In other words, a list of offenses that you can include other acts of the defendant that are part of the same course of conduct, common scheme, or plan as the offense of conviction. It just so happens that robbery is not one of those offenses. It's specifically excluded. So the answer to your question would be no. You would not be able to include those other robberies into the defendant's relevant conduct.
Okay, so the short answer is no.
That's correct.
Okay. Rusty, what do you do if the defendant has accepted responsibility for some counts of conviction but not for others?
Yeah, again, I think as we mentioned on the video, the sequence of guidelines application is such that you have finished the multiple counts part of Chapter 3, Part D, before you get to the acceptance of responsibility part of Chapter 3, which is Chapter 3, Part E. And again, the sequence of application is one of the underlying principles of correct guidelines application. So at the point that you've reached acceptance, you've already gone through, made the determination of a single offense level that is representative of the multiple counts of conviction. And so necessarily, the determination of acceptance will be a reflection of all those counts of conviction. So if a defendant has not accepted responsibility for all of the counts of conviction, then that defendant would not qualify for acceptance.
Okay. All right. Rachel, if counts are going to be grouped, is it necessary to apply the guidelines for each count of conviction?
Yes, Nancy, it is necessary. One of the reasons why is that it's nice when you apply the guidelines to each count of conviction. Sometimes you'll notice as you're going through your application that some of your counts are going to group together because you will have applied, for example, a specific offense characteristic in one count that incorporates behavior in another count. So in one sense, it's good for you to do that so that you can determine if your counts will group. When you're grouping at Rule D, remember, you're going to be applying one guideline one time. Now, when you're grouping at rules A, B, or C is when it's extremely important to make sure you apply the guidelines for each count of conviction, because you're going to be picking the highest of the counts. So in order to determine your combined offense level, you're going to have to do that for each count so that you can determine what the combined offense level is for the counts that are being grouped.
Okay. Well, very good. I do have a question, and it's actually from Jim Hobden, pretrial from New Orleans. And I understand it might be a little technical, so we think Rusty wants to handle this one. Could you comment on departures for behavior on pretrial release, especially downward departures for good behavior? This seems to be something new, or at least it might be new to some folks.
Well, it sounds like you're contemplating a departure, and again, we have the criteria from our departure roadmap, and I don't know that we've mentioned that. I don't even recall the video getting into that, but on our website, we also have the departure roadmap. And this would sound like a factor that probably has been taken into consideration in some fashion in acceptance of responsibility, I would say. And so it would have to be, is there something extraordinary that has occurred in this case regarding, say, acceptance or the behavior of the individual that takes it outside of the heartland that would lead the court to find it would be appropriate to depart.
Okay. Very good, and thank you, Jim, for that question. Another question we have is it always necessary for counts to have the same victim to group together? Whoever wants to answer that question. Rusty, would you like to try it
Sure.
again? Okay.
Is it always necessary to have the same victim? Well, the rules that we have for grouping, rules A, B, C, and D, rules A and B do require that you have the same victim. Rules C and D do not have that requirement. And in fact, probably the rule that's most often used for grouping, Rule D, most often I would think you probably do not have the same victim in those cases. Say you have multiple counts of fraud. Each count of conviction may involve the defrauding of a different individual. But nonetheless, we tell you if those counts are listed under 3D1.2D, as the fraud guideline is, then you use an aggregate of all the losses in those offenses and apply the guideline one time. So you've grouped them together despite the fact that you have a variety of victims for those counts.
Okay, very good. Thank you. We do have one question left, unless we get another fax that would come in before we end this question. So I'll give this to Rachel and let Rusty rest a little bit. Can more than one grouping rule apply? And if so, how do you decide which rule applies?
Short answer is yes. More than one grouping rule can apply. There was an example for a Rule C grouping in our videotape that we just watched, in which you had two counts of conviction, an assault on a teller and a bank robbery count. This would be an example of a Rule C grouping because there is a specific offense characteristic at the robbery guideline that's going to incorporate the injury that occurred in that assault count. Okay? This is also, or could also be, a Rule A grouping because you have the same victim and the same act, an assault that occurred on the victim during the course of the robbery. Which you choose to apply, either Rule A or Rule C, isn't really going to matter because the rules for grouping are the same in that you pick the highest offense level of the two counts. So in the end, you should be coming up with the same result. You may also have situations in which you're trying to determine whether something is a Rule A versus a Rule B grouping. You know you have the same victim, but you're having a hard time determining, do I have one or two acts here? It's not necessary to split hairs over whether you have one or two acts because, once again, your end result should be the same in that you are picking the highest offense level to determine your combined offense level for that group of counts.
Okay, very good. Well, that concludes our question and answer period. We would love it if you would fax a question in. We have maybe a few minutes left. But before I give you some concluding remarks, I'd just like to ask Rachel and Rusty if you have anything else you would like to comment on.
Well, I will say that, having had the questions on multiple counts and also the video presentation that was talking about use Rule D first before perhaps using Rules A, B, or C, because we find that's the easier approach. And that is, again, to refer you to our website to what we call our multiple count checklist. Is something that we've used over the years, and we think it does make it easier to go through these grouping rules to decide are the counts going to group or not. and particularly in light of the answer that Rachel had to give on the question about does it matter which rule they group under. If one rule is easier to go ahead and make the determination on the grouping, use that rule rather than getting into the arguments. Do I have the same victim or don't I have the same victim? Gee, if you have the specific offense characteristic that you know is there that is going to group them together, you don't even have to get into that argument.
Okay, great. And Rachel, do you have something you'd like to add?
Just my usual plug for the helpline. It does operate Monday through Friday, 8:30 to 5 Eastern Standard Time. The number for that again is 202-502-4545, and anytime you have a question regarding guideline application, please give us a call.
Thank you both. Really appreciate your being here. It was wonderful.
You so much.
Well, this concludes our broadcast for today. I hope the broadcast has been helpful and informative to you. There's one more thing I would like you to do, however. Remember in your participant guide, packet, again, there is a form that we would like you to fill out. It's a fax form. We're always asking for this because it is very important to us. And it's important because we want to know how many of you are out there actually watching us, whether it's today or whether it's going to be during a training program that you're watching later. And also we want to know your reaction to the information that we're presenting to you so that it helps us make some decisions about what broadcast we want to do in the future. So do us a favor and please fill out that evaluation form. I really appreciate your staying with us today. We really enjoyed having you. Thank you again, Rusty and Rachel.
Thank you.
Thank you.
And I'd like to sign off and say goodbye and have a wonderful day.